My name is Hine. I've just set up my own employment specialist boutique. I've had 20 years of experience in other larger firms, and I've decided to do it myself, largely because I want to provide that professional, commercial, user-friendly service to my clients. So what I'm going to talk about today is something on recruitment and best protection for your business. It's something I'm passionate about because not enough companies really take care of their business and protect it as much as possible. Just moving on to recruitment itself, just a few comments on that before I turn to the main area of topic is, not enough companies, in my view, do enough due diligence about the people they're recruiting. It's very easy just to have an interview or a second interview and think that's it. Quite often it's a very good idea to perhaps get them to meet the team in a social setting, things of that nature. Because believe it or not, 40% of senior executives fail in the first 6 to 18 months. And the main reason for that is wrong cultural fit. And had they done more due diligence at the early stage, then they would have realised that perhaps this person wasn't the right person for the business. And past success is no guarantee of future success. It's no good saying, well, look, there's your desk, get on with it. You need to integrate the person into the organisation and to really help them. So don't just interview, make sure you do your due diligence, make your offer conditional on satisfactory references, and hopefully if you take time about it, you will recruit the right individual for your business with the right cultural fit. But I'm going to really talk about protecting the business. So you hire people. Has the business been protected from its employees and ex-employees? And of course the best time to get people to sign up to what you want them to sign up to is the start of the recruitment process when they're employed. And the issue here is that people are so anxious to get someone new in, they're anxious to sign up with you, and of course sometimes the contract is rather left by the wayside and it's done some weeks later. Far better really to do it right at the outset so everyone is absolutely clear, getting the best terms for the contract, best terms for the business, to maximise the protection for the business and to insist it should it all go wrong. And that's when I'm called in. It goes wrong, they want to get rid of somebody, it's not worked out, and of course what do we turn to? We look at the contract and see what it says. So really the question I have for you is, can you afford to leave your business unprotected from your employees' ex-employees? And just to give you a few examples of why I say no, I had a client recently who sent me a service contract for a director who'd been with them for some, 25, 30 years. And they were deciding to go and join a competitor. The chief executive rang me up and said, look, can you have a look at their contract? I think we're all right, aren't we? Well, that contract was 20 years old, had not been renewed in that time. And unfortunately, I had to say to him, I'm afraid it's not worth the paper it's written on. So in other words, once that contract ends, you have no real protection for your business. So that person will be free to go and join a competitor, perhaps take clients with them, and there was very little they could really do about it, simply because they hadn't had their contracts reviewed in 20 years. I also advised a company recently, they were setting up a new business. They looked around at competitors in the marketplace to see who they could pinch, and they happened to find a company that was restructuring. And they were transferring all the assets from one business to another business. And when you do that, there's a horrible piece of law called 2P, which says that those employees transfer across, but employees can elect not to transfer under 2P. So 17 of these people elected not to transfer, which meant that their contract by law came to an end. My client was free to employ them the very next day. And the way they drafted their restrictions, the clients with whom they dealt, they did it by an alphabetical basis. So those who were employed on clients A to H, we switched them round and they worked on I to X. And those that worked on I to X, we switched them round to work on A to H. And therefore we got round the covenants, all because they weren't drafted properly. Sometimes people think about these restrictions in the contract and they say, well, it's a myth. They're not worth the paper they're written on. Well, wrong. I had a client who I've had to go to the High Court about recently. This was a sales manager of a business. He, believe it or not, whilst employed, set up a rival business, speaking to a junior employee. He had taken the client's database of contacts and sales leads. He'd already approached supplying rival suppliers with a view to getting the products to supply to the customers, and he'd already started to approach some of the customers, believe it or not, before his employment had ended. He then said he was going to join a recruitment business because do something different, so the client released him from his contract. Well, once we discovered this, we were able to go to his contract, see what it was drafted. We went off to the High Court and we got an injunction, court order stopping him from using that confidential information and from approaching our clients and customers. Now, this client had had a problem in the past, and the last time it happened, they lost £2.5 million worth of turnover. Luckily, they had contacted me after that. I put in place the right restrictions, and the High Court upheld them. So it stopped this rival business in its tracks, and the company were able to protect themselves. So, drafted in the right way, it can make a massive difference to that business should there be a threat posed. So what are we really talking about in terms of protection for the business? Well, we're talking about the confidential information of the business, including databases and what's on those databases. We're talking about the intellectual property, and we'll come on to that in a moment. And we're talking about protections during the employment relationship and after the employment relationship, and what can we do about it if those things are breached. So, looking at the contract itself, a lot of companies just take a contract, borrow it, put name, address and salary in and think, well, it looks about right, I've done what's necessary from an employment law perspective. And that's always dangerous, because what people forget is you can tailor that contract to your business and to what your business needs are. And too few people do this. And the thing about this is, it doesn't cost a lot to do this. You know, you're talking perhaps in the region of £1,000, £1,500, something of that nature, to get a proper contract in place. But boy, if someone leaves and tries to take those clients with them, like that other client who lost £2.5 million, £1,500 would have been a good investment, wouldn't it, at that stage? So, looking at the contract itself, look at the express terms. Get the title right. What's their title? Are they a director or not? Have a probationary period. And probationary period is something where you have a trial. So you look to see whether that employee is suitable for a period of time. If they're not suitable, then you can get rid of them on a shorter notice period than after the probationary period. So many companies, though, have a probationary period. They don't do anything with it. The probationary period comes and goes. Say it's 3 months. 9 months later, they ring us up, or perhaps even 12 months later. They say, look, this person's no good, I want to get rid of them. Okay, well, how long have they been no good? Well, all the time they've been here. What have you done about it? Nothing. And of course, at the 12-month period, they have unfair dismissal rights. So then you've got to have a fair reason to dismiss. So if you have a probationary period, use it. And then you can really see whether the employee is good enough. You can have the right to extend it as well. And that can mean that you're really having a look at that employee, tailoring that employee to what you want and making sure you're getting value for money. If you've got someone who you're paying after all to do a good job, if they're not doing a good job, why are you still paying them? Why have you still got them? Get them to perform in the right way. Length of notice. What sort of notice period are you going to give people? If you've got a senior person, if they have a longer notice period, you can hold them to their contract for a longer period than if you just have a really short notice period. So it can be a protection for the business. Of course, the corollary of that is that you have to pay them for their notice period, and perhaps they may not be working during it, but at least you can hold them to it, and therefore you have some protection for the business. You might decide that you want someone out of the business straight away, and you pay them their notice in lieu. You don't want them around, the contract comes to an end. Well, if you're paying them in lieu, why pay them all the benefits for what they would have been in a period? Just pay them the basic salary only, but the contract has to say that. If it says that, then you can do that. But a lot of contracts don't say anything like that. So when they are terminating someone, they're having to pay them all their salary and all their benefits. Well, you don't need to do that. And garden leave. Garden leave's another piece of protection. That means if someone hands in their notice and they're going to go off somewhere else, you can ask them to go home for that notice period, effectively work in the garden, not do any work for your clients, not contact your clients, and you've got all the contractual protections for that period. Again, it's quite useful. Confidential information. Very important for your business, your trade secrets, your pricing structures, your strategic plans, things of that nature. Make sure that is defined and you know what it is. And also have the right to get those documents back, either during the employment relationship or at the end of it. Think about your intellectual property, we'll come on to that more in a moment. Restrictive covenants is what we call those covenants which apply after the contract has ended, and we'll come on to that. Look at the person's previous covenants. If you're hiring somebody, do they have any restrictions which are going to prevent them doing what you want them to do? Will it prevent them from bringing their clients across to you or approaching those clients? Again, you need to have a look at what they've got in their contract. Are you going to give them the benefits from day one? Or could you say, well, actually, if you successfully pass your probationary period, then we'll allow you into the benefits. So it can save you some money. Some people give sign-on bonuses. Well, have the right to claw that back if they leave within a period of time. What is the bonus scheme if you're having a bonus scheme? What are the terms of that? Make sure that if actually they leave at the time or under a notice at the time the bonus is due to be paid, that they don't get it, they're not entitled to it. So the whole idea of bonuses really is to incentivise people to stay. But again, if the contract is silent on that issue, you can't use that sort of protection. Have a right not to work or have an interest in any other business. You don't want people doing things on the side or perhaps involved in rival businesses, specified in the contract. Some people pay relocation costs, training costs, have the right to bring that, get that back, have the right to suspend them in certain circumstances should there be a disciplinary investigation. If you haven't got it in the contract, you can't do that. And obviously you have the right to reclaim holiday pay taken in excess of entitlement. So these are all things during a contractual relationship that people often forget. Now, confidentiality, I've already mentioned. It's the things like the trade secrets, business plans, strategy, etc. But so few employers really define what they mean by confidential information. And of course, confidential information for your business may be somewhat different from somebody else's business. Get it defined in the contract, and then it's absolutely clear, and it can make it simple. Intellectual property. Now, I was just talking about Dragon's Den earlier on. It's amazing, isn't it? People, as soon as people present a business plan at Dragon's Den, one of the first questions they ask is it protected? Have you protected your brand, your IP, your trademark, your patents? And I'm afraid there are a lot of businesses out there who have created things, processes, etc., and they haven't really protected it. Well, there's nothing to stop somebody else perhaps mimicking that or taking it from you. So make sure it is protected. But also, you're having your employees working on your intellectual property, and although there's an implied right to say, well, look, if you're working for me and we're paying you, any intellectual property you create belongs to the business, it's obviously far better if you have it specified in the contract again. So get those clauses in there to ensure that the employee fully understands that that's what it belongs to them, and they must tell you, the employer, about anything they create. Now, this is the main areas post-employment. So we've done during the employment relationship, now we're talking about post-employment. And this is the area where you don't want people going to a competitor, taking employees with them, taking clients with them, and basically interfering with their suppliers. And these are the main protections that you can have after the employment relationship ends. Now, just a simple proposition: an employee is free to go and work for whoever they like, but a business is entitled to protect its legitimate business interests, but only insofar as it's reasonably necessary to do so. And the question is, what is reasonable? And that depends on the business, depends on the individual you're employing, their role, and what protections that business really needs. So we'll come on to look at that a bit further. So, very simple way of explaining it: if you have a chief executive versus a junior salesperson. The chief executive, no doubt, is driving the business forward. He is aware of all the strategic plans. He knows where the business is going. He perhaps may know he's got the highest level of confidential information within the business. He may not have that much technical knowledge. He might know about the products. He probably doesn't have that many client relationships because it's probably dealt with more lower down in the organisations. He might know a few suppliers, but he will obviously know the senior and key people in the management team. Junior salesperson, in comparison, may not know all the confidential information at the top. He will certainly have client relationships and supplier relationships and be part of the sales team. So the issue about protections here is, for the chief executive, the non-solicitation of clients, non-dealing with clients, is probably not going to be something that the business really is going to rely on very much. Non-poaching of senior or key employees, they will be, but the only way in which to protect the confidential information is to have that chief executive not be able to work for a competitor for a period of time. And that's where the non-competition element comes in. But for the junior salesperson, non-solicitation of clients, non-dealing with clients, non-poaching employees is probably enough to protect the business, and therefore a non-competition clause is probably unlikely to be enforceable against them. So this is the point. You tailor those protections to the individual that you're dealing with. Things like the length of the restriction is very important. The more senior you are, the longer the restriction is likely to be enforceable. And the issue really comes when something happens, you get out the contract, you have a look at what the restrictions say, and then a court has to decide whether they're enforceable or not. And if they've been well drafted and tailored, then you're likely to have the best possible protection for your business. If they're not, if someone's just copied a precedent, then you may find that they're unlikely to be enforceable because they're too wide and too long. And that's the key point. So the considerations in looking at what sort of restrictions to put in place really are the nature and the scope of the business, the sort of status, position of the person, geography. Which area does your business operate in? Does it operate overseas? Is it just in the UK, or is it just an area of the UK? So again, geography might be important in order to limit it. How long do you want this restraint to be? What's the individual's notice period? And if you put them on garden leave, is garden leave taken into account in terms of the restriction as a whole? Have they received legal advice about the restrictions before they entered into the contract? And really, the key thing is, what are you seeking to protect, and does your contract do that? Now, what can you do about it if it goes wrong? Someone goes off, they breach their contract, and you've got the contract, you can do something. So the issue is that you have a claim essentially as a business for damages for breach of contract. Like the client I explained, you can go off to the High Court and get an injunctive relief, i.e. an order of the court, requiring the employee and the new business to adhere to the terms of that contract. You have to give a cross-undertaking in damage when you do that, but you can also get search orders from the High Court. So for example, if you think that this individual's been using a whole load of computer equipment, they've taken your database and you need to find it, then you can get an order from the court going in and seizing those computers in order to have them examined. Now hopefully you don't have to go down that route because that's quite expensive. But normally when you find that there's been a breach, you write the appropriate letters to the employee and the new employer, and if they've been well drafted, they will receive legal advice. And no doubt what normally happens is that you reach an agreement fairly quickly. It stops that employee in their tracks, you reach an agreement, and you stop the breaching activities taking place. But of course, if they won't reach an agreement, you may have to go off to the court and get the order and continue with the action. So, really that's a very quick run through. What I wanted to say to people in terms of their business is, look, it doesn't cost a lot to put these things in place. Each business needs to think about their own business and what protections they are really seeking. And do have a look at your contracts. Don't let them get out of date. The law does change, things need updating. But the key thing in terms of recruitment is when you're recruiting a senior or key person, that's the time to really look at it. Get it tailored, get it in place. Have you defined to your employees what your confidential information is? Do you know what your intellectual property is? Have you protected it? What do you really need to protect and from whom? What can quite often happen is that sometimes there'll be a review from time to time, or something will happen like what happened to my client, and they say, right, we've got to stop this, we've got to review our contracts and get the right protections in place. Now of course, if that employee is already employed, you have to get their agreement to that change. And how do you go about that process? But it is important that if you need that protection, you can really require your employees to sign the new contracts. If they don't do so, you have a choice whether just to leave it or to say, well, it's so business critical for my business, what we're going to do is terminate your contract of employment on notice, and we'll offer you the new contract the day after that notice expires, and it's your choice whether you accept it or not. And provided you've got sound business reasons to do that, you can defend any such claim that they may make for unfair dismissal. The other point really is consultants. You may have consultants in to help your business in different areas. It doesn't mean you don't need any protection against them. So if they do a piece of work for you, for example, what you don't want them doing is doing the same piece of work perhaps for a competitor, whereby they may reveal your confidential information. So again, you can get protections in place for consultants or people who are helping out on your business. So I really finish off with the question I asked at the beginning. Can you afford to leave your business unprotected from your employees, ex-employees? I would say no, it could be extremely damaging. So I would suggest that those of you who have businesses, have a good look at your contracts Do they do what they're supposed to do, and make sure you protect your business as much as possible? And the reason I'm passionate about this is because I come across so many businesses who don't do this, and they may just take a precedent, and unfortunately when things go wrong, they kick themselves because they could have sorted something out a lot earlier. So that is a very quick run through one particular area of employment law, and I appreciate it's vast, and there's all sorts of other areas, but I'm very happy to take any questions on this area or any other area if that was of interest.
I find it very clear, those complex areas, you've laid them out in such a way that a non-lawyer can actually begin to understand what employment law is. I've got a very prominent business sitting over there. They gave a very eloquent presentation. I think this is a wonderful display of a complex business coming up, and you deal with a lot of recruitment, and I think this applies to you as well. What I see the best part is that you have given an insight into post-employment area as well. Let's say a person has left, and that is what the most common sense is that when the person is left, if he can do a lot of damage and you are unprotected, but actually I can see that from the contract is well laid out, you are protected.
Yeah.
In this competitive world, there are wrong thoughts going out, and I think one should protect. Mm-hmm. The other area you touched was that the contract people have already signed, they can be offered a new contract, and I think that loyal employees will have no problems.
Yes.
The problem will probably generate from those people who have dual thoughts about the company. But people who want to stay with the company, they have thought about it a long way, they probably will just say, it doesn't matter, it's a document. We will sign anything. So I don't see that a problem with many companies. One thing I'm slightly unclear about, which I really want to highlight, is that, okay, you said the court will do an injunction against the people to stop doing the business.
Yes.
But what is the damage they've already caused? Financial damage.
But you see, at that stage, you don't know. So what you're saying to the court is, look, this person is breaching, and you have to be completely open with the court. You may have, for example, some emails from clients they forwarded on to you because they're loyal clients and said, by the way, so-and-so has approached me, were you aware of this? And in this particular case with my client, someone had spotted the new business and had forwarded on an email that they'd received. So at that stage, you don't know what the damage is. What you know is that there's been a breach of contract. And what can happen is that you can require an account of profits from that new business. So if you can ascertain, and it may take obviously some months to do this, that business has been diverted away from your business to the rival business as a result of the breach by this individual, then the loss of profit that they have lost on that deal will be your damage. Because they haven't incurred the cost of doing the work, but it's the profit element they've lost as a result. And it's that is the damage, essentially. And that's why an injunction really stops things in their tracks. The court has to decide, and you may then need to continue with the action and have a trial as to whether there's been a breach, and secondly, what the damage of that breach is. And you may find actually down the line that the damage is far higher than you realised, because of course you don't really know who else they've been approaching, what other clients may have diverted work or given work to them as a result.
So what is the recovery of the damage about? Can the damage be recovered financially?
Yes. So it could. If you can prove that you've lost a profit as a result of that, then they'll be awarded the profits. Plus, you should get most of your costs of the action that you've taken if you're with the winning party. I mean, generally costs the court will have to assess, but I'd say some in the region of perhaps 2/3, 3/4 of your costs you'll get back as well. And these things are quite expensive, so you don't do this lightly. So, for example, this injunction has cost my client something like £20,000 at the moment in terms of costs, but at least it stopped it in its tracks and stopped any further damage to the business. And we've yet to examine the computer equipment to see what they've got on it.
So the person who caused the damage is not liable for litigation?
Yes. So you would sue the individual and you would sue the new employer. And often what you do when you have this scenario and you're writing to the employee to warn them about the breach, you will write to the new employer making sure they're fully aware of the restrictions, and they are then on notice that their new employee has to adhere to those restrictions. Otherwise, they may be involved in an action of inducement to breach contract. So they can be very effective, and actually recruitment is rife, unfortunately, with this. And insurance is another one. I had there's an interesting case recently where, I won't bore you with the full details, but there was lots of poaching going on between rival insurance businesses, in the course of which the individual who was the main arbitrator of this lost 15 mobile phones. Because obviously didn't want his calls being traced. So somehow these 15 mobile phones went missing. And these are the tricks people do. They will go to quite serious degrees in order to have that business advantage.
And the period of probation for an employment, what is that? How do you define a period of probation in employment law term?
Well, period of probation is really a trial period to see the suitability of the employee, not only for them to see whether they like the employer, but for the employer to see whether they like the employee. Generally, it depends on the seniority of the individual, but I would have that 3 to 6 months, and also have the right to extend it. Because sometimes, you know, the length of the period is not really sufficient. You might find someone's doing okay, but a bit more training, you might want to reassess them a bit further. But provided you've got that in the contract, then you can utilise that tool.
Yeah. I mean, one more question on this part, that sometimes the employees' negligence can cause damage to the company. An example could be that somebody not taking the phone calls, for instance, or not inputting the data accurately in the system.
Right.
Is the company covered under employment law for that damage?
Generally no, but you can put provisions in contracts which will cover that eventuality. It's quite common, for example, in the retail sector to put something in somebody's contract about if the till is short or they've made a mistake in that regard, that you may be able to recoup the losses that the company has suffered. Or, for example, if someone is using a company vehicle and they have negligently driven in such a way where there is damage, or they've damaged the property of the company, which is not irrecoverable because of the excess, then you may be able to require the employee to pay for that. But generally you're vicariously liable for the acts of your employee as an employer, and therefore you would have that sort of situation covered by your insurances as a company.
Yeah, I think this is an area where probably there are quite a lot of grey areas, because you're training a person under a probationary period.
Yes.
But after the probation period is over, a person is fully trained, then is that person not liable for damages once the training is complete and the probationary period is over?
Well, you're really talking about the area of negligence, and most employers don't really think about suing their employees for negligence and damages. So it is limited in certain areas, but I suppose there's no reason in principle why you couldn't put a contractual provision in saying in the event that you do X, Y and Z, we will hold you liable for any damage the company suffers as a result. If that's a contractual term, now most employees would think, well, what's all this about? I'm not going to agree to that. But there's no reason in principle why you couldn't put those provisions in, but you don't generally see them very often.
It depends on the type of the business.
Yes.
The data entry is critical.
Yes.
Like if the data entry is actually generating certain queries or macros in the system, and the macros fail because the date of input, date of birth, for example, was not entered in the right way, and then you miss the patient's records, they will not filter in the results, and the reports don't go out in time.
Yeah.
I'm talking about a specific system here.
Yes, you can have specific clauses about that, but you could also include within your disciplinary policy, if you're taking disciplinary action against an employee, you can have in there that it's not just, say, warnings. You can have other financial provisions that may enable you to, I suppose, doctor the employee's pay in the event of damage by the employer.
Great, thank you.
Unfortunately, with employment law, it's always the employee that gets protected, and we're protecting ourselves
Yes.
from being sued.
Yes.
Because it's very difficult to prove that someone is negligent, because you've got to prove that you've trained them, you've documented that you've trained them. But it is hard, and the time, it's like the effort it's costing to pursue that. It's best to kind of.
And sometimes
manage.
the employer may not have the money.
Yeah.
If you've got a large damage that's been caused, are they going to have the money to pay those damages?
After the probationary period, the situation should be balanced, that you've trained the person, you've taken time to train the person.
Yes.
Then there's no reason why the same thing which was done properly has been done improperly. consistently,
Yeah.
one or two occasions.
No, I can understand the logic of what you're saying, but many employers don't generally sue their employees for negligence or hold them liable for damage.
This is the trend, but because of the consideration of the damages involved, sometimes it can be different. It can be a major chunk of damage.
Yes.
Not financial, reputation.
Well, reputation is a whole massive area of new employment law.
The liability that you earned over years.
Things like blogs, Facebook, all of these social media these days, employers need to think about controlling that because, of course, a comment made on Facebook could have serious consequences for a business in terms of its reputation risk.
Hi Nick, my name's Sam. What I'm really looking for is a little bit of clarification in terms of a 2P scenario that we've been involved in. Essentially what's happened is a client has decided that they wish to terminate the contract. I have made several requests via email and letter asking for the incoming contractor details, or indeed passing our details over to them so we can furnish them with the relevant 2P information.
Yes.
But he's refusing to do so. Where do the employees stand? Do they have a case for tribunal?
Well, so you're the outgoing contractor, is that right?
Absolutely.
Okay, and you're trying to explain to your employees what's happening about the new contractor.
Of course.
And they should ultimately, if they're wholly or mainly employed in that contract, they should transfer across to the new contractor.
Indeed.
That's essentially what 2P says, for those who aren't familiar with this lovely piece of legislation. The thing is, all you can do as an employer, your duty is to inform and consult, and consultation as if the transferee, i.e. the new contractor, is taking measures. But all you can do is do the best you possibly can. Who's awarding the contract?
Well, the contract itself has been awarded to another third-party contractor.
Yeah, but who awarded it to you? Council or?
No. This was purely done on a sort of sales basis where we've proactively called the organisation, set up a meeting. When quoted, they were happy with the price, and then we went ahead and decided to do the cleaning for them.
So there's no way you can get any information about who the new contractor's going to...
Unfortunately not. The only sort of information that we've been given is that the head office used this particular contract on several of the other sites, and so they've stipulated that they want this particular contractor to be used on this particular site.
Okay, well, have you requested in writing the information from the relevant party?
Yeah.
And make sure you keep evidence of that. I think all you can tell your employees is that the contract will end on this date, that your employment should transfer across to the new contractor. You are trying to ascertain those details as much as you can, but at the moment you cannot give them any further information. If, at the end of the day, they do bring a claim, then if you've done all you reasonably can, then a tribunal would take that into account in terms of any award for information and consultation. But also the issue about unfair dismissal, or automatic unfair dismissal for 2P if their employment comes to an end, should transfer across to the new provider.
Yeah.
So I think all you need to do is protect yourself as much as you reasonably can.
Okay. Thank you very much.
Hi Nick, Francis, Netlaw Media.
Hi.
Nice to see you again. Nick, this is something, obviously, there is a new... the government has now got a new stream, looking at apprenticeships. Now, obviously, looking at employment law, how does that balance with bringing on apprentices? Because obviously there's different sort of payment terms, structures that are put in place. You're looking at a longer period of time.
Yes.
What's the impact for a business taking on, looking at employment legislation? Is there any changes in the same structure you would normally implement for a full-time employee? Because obviously it's different levels of payment, different sort of input they'd have in a business.
Yes.
What's the...
Well, I mean, apprentices generally have slightly different contractual terms. They also will have different pay rates, but if they're apprentices, then they don't necessarily have the same sort of level of protections as a full-time employee. So in terms of the national minimum wage and things of that nature, there are different arrangements depending on the apprentice scheme that they're under.
Okay, so really just depending on the level it is, then you'd have to, so it could be different rules entirely.
But if they're an employee, if they gain employment rights, then you're into the same sort of situation in terms of termination and things of that nature that you would with a normal employee.
Well, on the same subject, apprentices, if a company hires an apprentice and they work for 11 weeks, do they have the same rights as full-time employees that were not hired under an apprenticeship program? or do their rights change after 12 weeks, even if they're on a 6-month apprenticeship program?
Are you referring to the agency workers regulations? Why are the 11 weeks versus 12 weeks?
Because I've heard a lot about 12 weeks being the cut-off point at which a company has to treat you as they treat their other employees. But if you're an apprentice, does that apply?
Depends on the apprentice scheme.
Okay.
I mean, I think in terms of the agency workers regulations, that there is a 12-week qualifying period there, which will start actually from the 24th of December of this year. And that's when those who are under an agency contract, as it were, have the right to equal pay versus a comparable full-time employee. That's why everyone needs to be having a look at how many people they've got who qualify in that sort of area.
Excellent.
But it really depends on the nature of the apprenticeship and the nature of the contractual terms that they have.
In terms of their contract with you, or in terms of their contract with the agency that supplied them to you?
In terms of the contract with the agency. So what the agency should do, if the agency is effectively employing, it's the agency who has to get the information from the end user as to what the rates of pay are, and to make sure that they're compliant. But the problem with this is, for end users, is I have a client who has nearly 600 agency workers at the moment, and they calculated the other day they had nearly 60 of them who would have qualified for these new rights had the 12 weeks been in. But what they don't want to do is give all their pay scales to the agency, because that made it filter down to their competitors. They don't want to tell people what their rates are, and therefore they're going to make a decision not to do it. You may do it on an individual basis, or an individual employee who raises an issue, but the risk is here is you minimise competitiveness for people using agency workers if they know what other people's rates are.
So do the same rules apply if it's someone that came from a government apprenticeship program, or are they treated as an employee?
Yeah, I'm not terribly familiar with the different apprenticeship arrangements, if I'm honest, because I don't often deal with those sort of areas. But I think you would have to look at the schemes and what the scheme rules provide for.
Okay, very good. Thank you.
And I think more interestingly, the government is looking at ways to try and alleviate businesses or help businesses. They are suggesting increasing the 1-year qualifying period for unfair dismissal to 2 years. Now, in my view, that's not going to make much difference. I'll tell you why: because people just try and get round it by using some form of discrimination angle, so they can still bring a claim. They're also thinking of having no obligation chats with employees. So at the moment you've got a situation where, say you have a senior executive who's not really performing and is not really working out for the business. What would be quite nice to do is go along and have a sensible chat and say, look, we don't think this is really working for us. We'd like to come to a sensible arrangement whereby you leave on good terms and we get somebody else. The problem is you can't have those without prejudice conversations with them unless there's a dispute. So you've almost got to create a dispute with this individual before you can have those sort of conversations, and that seems crazy. So I think the government have realised this, and they're trying to look at other ways where you might be able to have those type of sensible conversations with people rather than end up getting embroiled in some dispute before you can resolve it.
Pension schemes. Sorry, I've got to hit you with this one. It's coming into force, obviously, as we know, next year.
The auto-enrolment, yes.
Yes. Now, looking at pensions, obviously a lot of businesses, if you look at the SME market, have not really thought about or had to implement a pension pot for their employees, because obviously it's something which was undertaken on a personal basis. Now, looking at this, is this, and obviously looking at bringing on people like a new recruit, do they have to be offered straight away pension from the start, that you have to state this is going to be your pension scheme, this is who it's going to be with, or can it be implemented after the probationary period, whichever is in the company?
Yes. The current law is that any business which has more than 5 employees has to offer access to a stakeholder pension scheme. That's the minimum. When auto-enrolment comes in from October next year, it's starting off with the largest businesses have to make a contribution into a pension scheme for their employees, and there's auto-enrolment into that, and a lot of benefit firms now are talking to companies about doing it now, getting in early rather than leaving it to the last minute. But over the course of a number of years, the number of employees who will the business has to employ to require them to do this reduces over time. But eventually, after 5 years, everyone will have to effectively do it. But for small companies, not initially. But a lot of companies are already thinking of doing this, putting this in place, at an early stage in order to ensure they're compliant.
Would you recommend sort of small businesses to look now and start setting them up, or is it something, because obviously you've got now a leeway compared to say larger businesses, which obviously have a cut-off point?
I think small businesses should be planning ahead about how this is going to affect them and how do they propose to deal with it, because in effect it's another 3% of their salary you have to pay. So how are you going to deal with that? And it might well be that you can have a proper discussion with your employees about what type of benefits you supply as a business. And it may well be that there are things that you supply that they don't really like or don't really need, and they'd rather have other things. So it can be an opportunity to engage with your employees about what benefits you provide and how best to deal with this particular issue. Maybe, for example, they're prepared to take a slight salary cut to help with this, but they'd rather have another benefit as well. So,
like travel or something?
Yeah, or extra holidays, childcare vouchers, all these sort of things. And not enough companies really explain to their employees what value they're getting. So sometimes people will think, oh, I'll go down the road for an extra £100 in salary a month, but the benefits they're getting of the new employer are so much less, and they don't realise that actually their current employer's whole package is worth more. And because companies don't really tell people what value they're giving.
I think I want a clear definition between negligence, a negligent performance and a poor performance, because the laws attached to them are different.
Okay. Negligence, very simply, is where there is a duty owed by one person to another, or one party to another, there's been a clear breach of that duty, and that damage therefore has flowed as a result of that breach. Poor performance, the distinction there would be that they may, rather than being a clear breach of that duty, they may not be doing it as well as you'd like them to do it. So in other words, they're perhaps not putting in the effort as much. They're still doing it, but not putting in the effort. They're not, I don't know, doing 60 envelopes an hour, they're doing 30. It's not necessarily a breach, it's just that they're not performing to the same level, whereas with negligence there has to be a clear breach. So, simple example, someone's driving a car in a reckless fashion, they cause an accident and someone is injured as a result. Now, if their driving is clearly reckless and clearly in breach of the law, then that would be a negligence scenario.
Do you see the need of defining this specific to the job assigned to the person, because sometimes it can be very, very tricky? Do you think it's important to decide this in the contract?
I think often actually job descriptions are quite important for employees, because unless you specify out what it is you require your employees to do, they may not necessarily know, depending on what the communication is. And also it can be quite useful, because if you come to a disciplinary situation, say, look, we clearly set this out, what you were supposed to do, and you've clearly not been doing it, and you've got a document you can point to help with that process. I suppose the simple thing is, I hate to raise this in a negative fashion, but people, for example, who go in for an operation expect the doctor to perform that operation with all reasonable care and skill. If that doctor makes a mistake and that person is then injured as a result, that's often another example of negligence, where negligent cases come from.
I think I'll try and redefine that.
I knew that was a controversial one to raise.
Why that is important, because there are acceptable complications and there are unacceptable complications.
Yes, that's true.
So the poor performance is acceptable complication. Unacceptable complication is a negligent performance.
Mm-hmm. Yeah.
Sorry, I have to intervene here.
Your area, not mine, actually.